I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are knocking on the door of 221 on our compilation list. We will be in 3 different courtrooms for this one. Before we get into the courtrooms that we will be in, don't forget to like, comment, share, and subscribe. Also, commentary will be left in the proceedings that had commentary in them. Also, chapters will be added for your convenience. Now, the 3 different courtrooms we will be in on today. For the first time, we will be in the courtroom of Judge Elizabeth McClintock out of the state of Colorado. Shout out to Sovereign Citizen Chronicles for sharing this with me. Second, we will be in a courtroom out of Canada. And last but not least, we will be in the courtroom of Judge Phyllis Webster out of the state of Kansas. Guys, as always, I'm enjoying these compilations like you guys are. And listen, let's go ahead and jump into 221.
We have several cases. Come on up, sir. All right, these are cases 25T448, 25M318, 25M352, 25M375, and 25M395. Mr. Shadowins, let's see, you appear on bond today. We had a failure to appear, I believe, on May 4th. I'd issued warrants for your arrest on that date for failure to appear. I've been in contact. The doctor from Colorado Hospital, you were supposed to have an appointment on May 8th to do the competency evaluation on these cases that had been ordered by Judge Kilgore. My understanding is you did not have that appointment.
That would be correct, due to a change of address to the likes of which I am in possession of prima facie evidence. I have not had the opportunity to file into the record. So my apologies to the court for the failure to appear. I was in between addresses.
Okay. But
I did complete court requirements of Judge Kilgore and report to mental health. I was under the impression there were no active cases or pending hearings, according to the DA's office and mental health. I was told
no
by email. I have the emails, ma'am. I was told.
Okay, show me the emails then. Because I spoke with or emailed with the doctor this morning to confirm that you did not follow up on those appointments. And she had said that no, you did not follow up on those appointments. And we need to get these back on track because these cases are pending. And I need this competency evaluation to get done so we can get these cases moving.
Ma'am, I was under the impression, for the record, that mental health was to report back to me, end quote. She said she was going to talk to you. The statuses of these cases has been a matter of question.
No, these cases are still pending. These cases need to be moving. The only thing that's holding them up is a determination about your competency.
Ma'am, I demanded these matters be settled by right of equitable subrogation.
No, sir.
Judge Kilgore admitted on record it's a, quote, failed prosecution.
No, sir. I've listened to all of the records in these matters. The last time you were in court, what was ordered is you were supposed to go through these competency evaluations. You were supposed to get those done. And if you did not get them done, you were going to be sent back into custody to have them done while you were in custody. That was the last thing that was ordered in these matters.
I have the emails and
Sir, I have the records of when you were in court.
I have not
and I've
entered evidence, ma'am.
Sir?
How would you like me to enter the evidence you asked for into the record, ma'am? The clerk was unable to process it this morning.
So
I have prima facie.
What are these emails?
This is mental health as well as postal receipts for the change of address. My mail was on hold.
So you have emails or letters? Which are they?
Ma'am, may I speak to answer?
Emails or letters, sir?
All of the above. as well as postal receipts. My mail was on hold. I apologize to the court for my failure to appear. I was not served. I was told by the...
What? Served with what?
Ma'am, if I may speak and
Served with
interrupt it,
what,
please.
sir? Served with what?
Any hearings, I was told...
You were in court
Ma'am,
the day that you were supposed to be here. You were told your next court date.
I'd like to be heard on a
Sir.
record on the matter to answer your questions. How would you, first and foremost, how would you like me to present this evidence into the record?
Give it to my clerk.
Thank you. I was not noticed of any hearings. I was told by 2 senior investigators at the DA's office, I quote, did not have any pending cases or hearings. I have a video that went viral on the internet of the DA's office obstructing justice. I was unable to file discovery into the matter, Your
Sir,
Honor.
the
It's on
DA's
the-
office does not give notice of court hearings.
I was
You
ejected
here-
from the building.
No, sir.
I signed up with the
Sir.
sheriff. I signed up with the sheriff's office to be noticed from the court. They could not do that, ma'am, because I was in limbo with my address. All my mail is on hold. You have the postal receipts, prima facie.
Sir, we do not provide you notice of court dates by mail.
I signed up for a contract with the sheriff's office to be noticed of hearings. No such notices came through. My mail was on hold with the post office. My apologies to the court for the failure to appear. I was under the impression there were no pending cases. There were no pending hearings. Mental health told me they would report back to me after petitioning the court for clarity of the status of the cases. No such notice was given nor service from the courts at all, Your Honor.
No, Mr. Shadowins, that is incorrect, and you know that is incorrect.
You're in possession of
No,
prima
Mr.
facie
Shadowins.
evidence.
No, Mr. Shadowins, I'm not in notice of anything.
I said possession.
No,
Point of
sir.
clarity. You have physical
No,
possession
sir.
of prima facie evidence to show just cause.
No,
Am I
sir.
entitled to understand the nature and cause of the proceeding today, Your Honor?
Yes, sir, you are, and you have
Thank
notice
you.
of
I was under the
proceeding.
impression,
Stop talking over me, sir, now.
I don't understand the nature.
Stop talking over me. I am trying to explain it to you.
Yes, ma'am.
You have notice of the proceedings. You have been served a summons and complaint in each of the proceedings. That has been explained to you. You stop. Take the gum out of your mouth and spit it in that garbage can right now. Right now, sir. You have been served a summons and complaint. The documents you have showed here are just e-filing documents that are well from December of 2025.
Negative.
That has nothing to do with what we are doing
Your
here.
Honor, with respect.
Stop talking.
With
over-
respect to the nature and
No,
cause of
sir.
the, I
Well,
cannot proceed.
Stop talking over me, sir.
I wish to enter a plea into the record, not
Okay.
guilty, all charges. A jury
can
trial is
enter-
demanded, civilian due process of law is demanded. My question to the court on the nature and cause, I was under the impression I am here by special appearance to show just cause for a failure to appear. I have no other issues in front of me this morning, Your Honor.
No.
I was,
And you're going to be taken into custody today, sir, so that we can complete your competency evaluation that you have refused to
Ma'am,
appear
these-
for.
it's right
on
here, prima
every-
facie, Your Honor. I was told by mental health they would report back to me. No such
sir.
notice was given. I couldn't
Notice
receive
was
notice
given.
from the courts due to a change of address. I'd like to read the evidence into the record, please.
No, sir, you will not. You
Let the
failed
record
to
show
appear.
that I have been denied a defense. A trial by jury has been demanded. I have already sent all of this to the State Attorney General Phil Wise, who has obstructed justice and refused to respond in these matters. My right to equitable subrogation before Judge Kilgore was demanded thrice. I also challenged the jurisdiction of the court. Judge Kilgore admitted on record in front of Teller County Sheriff's deputies, Your Honor, quote, "It's a failed prosecution," end quote. I have since been retaliated against. Now, I have teamed up with attorneys, including the Disabled American Veterans. I'm moving this to federal jurisdiction.
Thank you, sir.
There's no victim
You're
in this
done
case, Your Honor.
Your bond is being revoked so that you may go
Who is
into
the victim?
custody and you may have your competency evaluation completed because your failure to cooperate out of custody in this matter. We will have the competency evaluation completed in a forthwith manner according to statute.
Okay.
I have been denied a defense. I was denied the right to read evidence into the record. And I was never given discovery. I could not plea without evidence, Your Honor. That's all a matter of record. There is no victim.
Appointed the office
What is
of
the
the
Sixth
public
Amendment?
defender in order to represent yourself represent you.
What is the nature of a crime having
in
been
this
committed?
matter. In all of your cases, you have been provided notice in regards to the summons and complaint and all of the discovery in this matter.
Which I have abated via affidavits the prosecution has not responded to. My facts remain concrete evidence. There has been no response from prosecution. I don't even have evidence and discovery.
Thank
The
you.
accounting has been demanded for settlement. This is unconstitutional, Your Honor.
Thank you.
I cannot stand for this.
Child was going down.
Let the record show I have been denied due process of law, civilian due process of law, a trial by jury. I'm still speaking, Mr. Sandlin. I must remain harmless. I am not done addressing this court, which is my First Amendment right.
Thank you, sir. Appreciate it. Yeah, so the public defender will be appointed for Mr. Shadowins on all of his cases at this time. In regards to his competency evaluation, that will be ordered forthwith in custody.
Understood.
So, and I would request that the public defender obtain discovery in all matters and provide copies to him. So there's no question that he has that information. So,
Understood, Judge.
All right.
I apologize, but would you mind reading those case numbers just so I can
yes,
get all of them open to us, please?
yes. They are cases 25T 448, 25M 318, 25M 352, 25M 375, and 25M 395. I've notified the Colorado State Hospital and Dr. Elizabeth Fuller that Mr. Shadowins would be taken into custody today, and then I expected them to complete his competency evaluation immediately.
Understood.
This can't be delayed any longer. All right. In regards to, do we happen to have the Teller County Jail online yet? No, not yet. All right.
Okay, you're welcome. Have a good day.
I forgot to give that to you too. That was supposed to be with the that's a bill of exchange.
Okay.
That was supposed to be with the package, and it was in the serve thing, and I got it.
Yeah, all good.
I misplaced it.
Okay, thank you.
All right, thank you.
Smith?
Perry, report.
You're up, bud.
All right. I'm Godfrey, but you guys keep insisting and call me.
Thank you. Yes, sir.
I'm here for that matter.
I don't need to reach out to town attorney. People step on that act.
Your Honor, I'm here for this matter today.
Good, then step on the act.
Well, no, that gives you jurisdiction. I'm not playing this game. I'm not playing the game, Your Honor. I'm here to settle the matter.
Okay, stop talking for 1 second and listen. You filed a bunch of nonsense documents this morning. Let me point out what you do in these documents that you signed. You signed Godfrey Lewis Norman Perry. You don't, it's not an.
Did you see how I signed?
Quiet.
I hyphenated my name.
Quiet. My turn, I said. Again, where it's highlighted, Godfrey Norman Lewis Perry. None of this incorporation nonsense. Another one. Godfrey Lewis Norman Perry. Godfrey Lewis, there's about 10 of them on that one.
It's a trust that I'm the beneficiary for.
Godfrey Lewis Norman Perry. That's you.
It's not me.
Get on the X.
It's not me. It's not me, Your Honor.
Get on the X. Now here's the problem. I sent you away.
If I get on that X, it's because I'm under duress.
Yes, go ahead. Under duress. Step on the dot.
So
yes,
you're.
Under duress.
Is every man not equal? Is
X.
every man not equal under the law, Your Honor?
Step on the X. Sheriff, help me step on the X. Sent you away once for assessment. You guys worried about your mental health. You start filing all these nonsense documents, I'm going to start worrying about your mental health again. You understand that?
Of course you will.
Now, what's your intention with regards to these breaches of probation?
I want to settle this matter.
Well, not guilty or guilty, please, sir.
I don't plead anything, Your Honor.
All right.
I plead to my
guilty,
Creator.
please, setting it down for trial. Time for trial on Ms. Brown.
Ms. Brown, since you brought the controversy, I want to bring remedy. What is the remedy?
The remedy is you'll end up in jail probably at some point in time. You don't start behaving properly. That's probably the remedy.
That's threats.
No, it's the law. Full day.
I think that's safe. It's primarily one Crown witness.
But there may be difficulties.
Yes.
Are you going to have a lawyer? You're going to represent yourself?
I can represent myself.
All right. So, do you have your disclosure?
Yes, he does.
All right. You have all your disclosure. It's your responsibility, sir, to be here on time, to be ready for trial. If you don't show up, there will be an arrest warrant for you. You understand that?
I don't understand legalese, sir.
All right. That's fine. Well, you certainly can write a lot of legalese for someone who doesn't understand it. Yeah.
I know what you guys are doing in
You
here.
always contradict yourself because you make no sense. Date for trial. Early date. Pass me the book. I'm not dragging this out for next year.
And I can advise put notice on that Crown will be relying upon certified copies of the probation order because I suspect service may be difficult.
Yep.
Again, I came in honor to settle the matter.
Well, I tried
But now you're in dishonor, sir. State for the record that you're in
Friday, April
dishonor.
28th of this year is your trial, sir. Be ready for it. You understand?
You're the trustee and I'm the beneficiary.
I'm the judge.
And you're not doing your duty as a trustee.
That's wonderful. Fill on the card, Friday, April 28th at 9:30 for trial.
I came here in honor to settle the matter and you're not willing to accept my offer.
You a bunch of nonsense.
It's not a bunch of nonsense. You know that it's a trust.
Silly documents that make no sense.
You're trying to maintain, are you trying to maintain the bankruptcy, Your Honor? That's what you're trying to do, to maintain the bankruptcy.
Yeah, all right.
Yeah, I don't own anything. You own everything.
I own
You're a owner. It's not your honor, it's your owner.
All right.
Time to be removed, Your Honor.
Yes, courthouse.
You don't have to, I'll walk it.
On your own. Walk by the table.
My car's up back.
Yeah, okay.
Terrorist organization.
And Judge, I am on standby on Mr. DeBus. Although I'm not attorney of record, I will be standing by though.
All right, and that's what I'm going to call now because it looks like it's between Mr. DeBus and Mr. Cochran. Well, I can't call, yeah. Mr. DeBus, you want to start your video? Okay, we are back on the record in 2023 TR 2777, State of Kansas versus Anthony Edward DeBus, with Jared Regier for the state, Mr. DeBus in person, and with standby counsel Darren Patterson. Standby because my prior contacts with Mr. DeBus led me to believe that he, even though he wants to represent himself, there's much about the legal system that he doesn't know or understand and would need the benefit or would certainly benefit, period, from Mr. Patterson's representation. So, Mr. DeBoos, at this time, you want to talk to Mr. Patterson and take advantage of his knowledge and experience in the legal system concerning this no driver's license charge, registration, and insurance violations?
Let me ask first, are we on the record? Is there a court reporter present?
Is there a court reporter present? This hearing is live. It is being recorded. Is someone sitting here with their little fingers clicking across the keyboard? No.
So you're saying that this is not currently a court of record?
This is a court of record because this is being recorded, subject to transcription at any time.
Okay. I would ask for a copy of that transcription.
Well, when you file a written motion and pay the transcription fee, sir, that will be arranged.
Okay. And Phyllis K. Webster, will you please recite your oath of office into the court of record then today?
No, sir, I will not.
Why are you refusing to do so?
Let's move along.
I would please like to have that question answered. On another note, I am appearing specially, not generally, under threat of duress and further coercion by the state of Kansas Corporation.
All right, sir. I did take my oath when I was appointed and when I was elected subsequently. Now, what is it I can help you with today? Do you want a trial, a jury trial, or do you want to enter a plea today?
It seemed like last time we had court, you entered the plea for me.
I did, because you would not.
Okay.
But yet what you were saying suggested you wanted a trial, so I entered the not guilty plea and set it for trial. Somewhere along the line, you led me to believe you wanted a jury trial as opposed to a bench trial. Had I been making the decision, I probably would have said bench trial. But somewhere along the line, you've made comments to make me think you wanted a jury trial. Now, I have not seen, let me double check. I don't think, Mr. DeBoos, that you have filed any kind of demand or request or notice for jury trial. Have you?
I thought that was entered into the last court session.
Well, I don't think you filed any motion. You told me apparently you told me you wanted a jury trial, but you never followed through.
I thought that was a decision that we made as the court.
Well, you and I did not make a decision of any kind. Mr. Patterson, do you believe it's acceptable for him to just say he wants a jury trial?
Your Honor, pursuant to case law, because there are at least up to 1 year in the county jail possible, if it's ever consecutive, then case law would state that he has a right to a jury trial.
Agreed, but does he not need to put something in writing to that effect that he wants one? That was my question.
Because there's an absolute right to jury trial, he would not have to put it in writing. It would have to be specifically waived by him, Your Honor, and I don't think he's done a waiver.
Very well. Do you agree with that, Mr. Regier?
Your Honor, what I can say at this time is pursuant to KSA 6238 subsection B, quote, on any issuable trial by right by a jury, a party may demand a jury trial by serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and found the demand in accordance with KSA 6205 and amendments thereto.
Mr. Patterson, in spite of that statutory language, do you think he needs to waive his right to jury trial? Did I hear that right?
Absolutely, Judge. Pursuant to case law, and I don't dispute the statute whatsoever, but there is certain case law that makes it a constitutional right to a jury trial if the sentence would be up to a year in the county jail, and in this case, consecutively, it could be up to a year, the longest possible maximum. So it would have to be waived by him, and he would not have to make anything in writing to receive that.
But you don't believe that case law overrules the statutory law, or do you?
This is a constitutional right we're talking about, Your Honor. It would trump the statute.
Okay. So, Mr. Patterson, when you say up to a year in the county jail, are you thinking if they were to be run concurrently, or I mean consecutively versus concurrently?
That would be the longest possible sentence when you start running them consecutively, and that's what the case law would state.
Do you have your statutory site or your case law sites by chance? I know you didn't expect to pull them out.
It's not one I keep handy, but giving a short recess, I can find that.
Well, now before you go to that, now, Mr. DeBoos, do you have any idea what's going on here?
I, as a common man, do not comprehend the legalese that you guys are using together. I can look up statutes and case law myself, and considering that this is dealing with a common right to all people under granted to us in restriction of government entities for the people itself, I comprehend that I have my right to jury trial, which I think Mr. Patterson, in his brief support towards this and towards me, towards my right to a jury trial, although I do not fully comprehend the legalese that is going on within the association between Jared Regier and yourself, Phyllis K. Webster.
All right. Well, Mr. DeBoos, the point is you do have the right to represent yourself, and you've told me you want to represent yourself, and I've asked Mr. Patterson to stand by, and you've already used him here for this purpose. So here's the thing, Mr. DeBoos. No, let me talk now, Mr. DeBoos. Here's the thing. If you're going to represent yourself, you need to be able to make your own arguments. You need to be able to cite your own law. And if you cannot do that, you have the right to legal assistance, which is why Mr. Patterson is here. And you've already this quickly run into a legal snag that he's made the argument for you. Does it not make sense to you? And do you not want to have his legal assistance to let him represent you?
I do not wish to be represented by an attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barricade was an unlawful arrest for
we're not going on
22-2401.
We're not going down that path right now, sir. Well, the issue is, so you do want a jury trial. Are you ready to proceed on Wednesday, Mr. DeBoos?
May I ask that there be an extension so that way I may fully research the procedures of the administrative criminal law which you're trying to try me under?
Well, I'm not the administrative law judge. That is yet another procedure.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic trial, and I am not an administrative law judge. So here's what we're going to do. How much time do you want this continued for?
30 days or so seems to be a standard.
Well, my next available jury trial date would be October 2nd and 3rd. So
2024.
2024. So that's when I will continue this at your request to. I'll grant your continuance, but that's my next available date. And your pretrial will be September 30th, 2024. Do you have any objections to that?
No objections.
And Mr. Patterson, do you have any legal authority that suggests that I reaffirm my oath for him? Do you have anything that says I should do that?
Judge, I'm afraid I've never researched that issue, never heard that issue.
All right. Well, same here. I do have my oath in front of me. I keep it handy, but I don't see the need to repeat that. It was good enough for the Supreme Court of Kansas.
I'm not threatening you. Say one more word and that's 30 days. 30 days.